Adjudication with you this morning. Just in case you don't know who I am, Sarah Lethbridge, I'm the Director of Executive Education here at the Business School, and these breakfast briefing series are part of our real desire to be closer to our business community as a school. So if you've got any interest in industrial funded research, in any short leadership programs, then please do drop me a line. I'm happy to explore those together. This topic came from a number of different leadership projects that we're doing with law firms at the moment as a school. And it's been really fascinating working with people like Hugh James and Cooper Legal to understand the challenges that the legal sector is facing at the moment. And the rise of the robots, AI, technology is a really hot topic. So I was really delighted when Professor Richard Moorhead agreed to come and speak to us this morning. He's Chair of Law and Professional Ethics, Vice Dean for Research at UCL. So in the great tradition of academic sharing of knowledge, thanks ever so much for coming to Cardiff this morning and sharing your wisdom with us. He's got 14,500 followers on Twitter. So I'm in awe of you.
That's not a good thing.
No? Successful Lawyer Watch .wordpress.com as well. So if you're not following his blog, then please do so. So thanks ever so much for coming this morning, Richard. Just to give you a heads up about the next event, on the 6th of March we're running an event looking at the Going Solo report published by Professor Andy Henley and the Federation for Small Businesses. On the 15th of March, Dr. Samuels is doing an event with Social Enterprise UK, looking at how we can develop closer relationships between the public and private worlds. And then on the 22nd of March, we're looking at sharing the findings of our quality and merit research from Carla Edgley, Nina Sharma and ACAEW. So those are our events that are coming up. I'm sure we're going to have a great time this morning, and without further ado, I'll hand you over to Richard.
Thank you very much. Good morning, everybody. Thank you very much for giving up your morning, if not your breakfast. Delighted to be here. I actually live in Cardiff, so I haven't had to come very far. I just wanted to say a tiny little bit about me so you know where I'm coming from. The first thing I wanted to say is I'm not an expert in legal technology. There's a lot of very technical stuff which I try to understand, and I try and usually fail. Where I'm coming from is I teach a course for my postgrads on the future of legal practice, and I come at that as a researcher, former solicitor who's spent a lot of time looking at the delivery of legal services, the quality, ethicality, incentives and those kinds of things, and used the future of legal practice as a lens to focus on how things are developing. So what I've been trying to do with the course, with the students, what I'll try and share with you today is just my thoughts on what seems to be working, rather than try to give you a sense of, oh, the robots are going to come and destroy all our jobs and lives and make us miserable. I'm not very interested in that. What I think is important is what's happening now, which has some traction, which has some value, which might be improving services or improving the way legal service businesses are operating. Sarah mentioned my blog. That's Twitter is not the labour of love. That's the labour of wastefulness. But the blog is something which I do care about a lot. I do spend a lot of time writing about lawyers and legal services and a bit about technology when interesting things crop up. So if you are interested, please do follow that. I really do enjoy that and use that as a vehicle to share interesting things, I hope. So what I wanted to try and do was talk a bit about AI, law tech, design and systems thinking, and really focus on those sort of current or near-term use cases, areas where it's being used. I struggled to think about how am I going to make this seem coherent, because there's lots of things going on, but they're going on in lots of different areas. And what I thought I'd do is I'd use ODR, online dispute resolution, as the framework for organising those ideas, but try and talk about both some, if you like, access to justice use cases and some commercial use cases, knowing that we've got quite a wide range of interests in the audience. So this is the structure, if you like. So I'm going to try and organise what I talk about in terms of information and intake, triage, so deciding whether cases should be taken on and how they should be directed, mediation, negotiation, preparation and adjudication, because they're essentially the stages of most of the current, at least, online dispute resolution processes. And while I'm not trying to evaluate ODR or say whether or not ODR works or not, hopefully a kind of byproduct of the talk is we might get a little bit of a sense of how ODR might work or might not work in practice. At talks of this kind, you typically get a few things said to you, which I wanted to sort of slightly distance myself from. This idea that AI is going to sort of exponentially overtake legal practice. And usually you get told there are sort of three exponentialities. One is the rapid growth in processing power, which has made some computational techniques plausible in lots of fields, including now law. The second is the similar growth in storage, which has enabled, if you like, large, sometimes called fire hoses of data to be used to try and solve all kinds of problems. And the third exponentiality is the Internet of Things, that all these devices that we interact with, be they in our fridges or our phones or whatever they might be, which create data, create traces of our real life, which can then be analysed for commercial or other purposes. Now, while that might all be true, and I think it probably is going to lead to a much greater use of artificial intelligence in the delivery of many services, including perhaps law, the thing that I think we should acknowledge straight away is there isn't really an internet of legal things. Very little of the legal world is online or connected, although increasingly firms are looking at connecting the information that they have in the different systems within the firm, in the files, in the case management system, in the financial management system, and so on and so forth. So we're quite a long way from an internet of legal things. Okay, that's all I wanted to say by way of introduction. So information and diagnosis is the sort of first area of interest. And any system which uses technology to link clients to legal solutions needs to understand those clients' legal problems. It needs to diagnose those problems, at least in general terms, and it needs to supply relevant information, perhaps tailored advice, to the client's situation. And the first question is that possible, or how is it possible? A second point which I'll come to is, from a business point of view, there are new, better, more efficient ways of engaging and getting into markets, getting customers, understanding how to market the business and deliver services. And deliver different kinds of services other than, if you like, simply advice. There was a noise there. Is that all right? The problem can maybe be thought of as the carrier bag of papers problem. I've done loads of work on litigants in person, and one of the things that I always get told is you don't understand how do you deal with a sort of slightly crazed person coming in with a bag of documents which they then dump on your desk and expect you to advise. That kind of chaotic sense of injustice which the lawyer then has to shape into something, work out if it can be shaped into something meaningful, and then take a case forward in a way which will help for the client. Well, here's one way how. They're sometimes called expert systems or managed pathways. This is from, I think it's called roadtrafficrepresentation.com. You can go away and Google it. It was actually built by a solicitor in his spare time, I think in his garage actually, even, the kind of old cliche, but it might have been his spare room. He built a website to provide advice on road traffic cases to his clients, and he does it all for free as a way of trying to capture the last bit of their case. So this is, if you like, our first form of artificial intelligence. You just program in the rules, if you like, the legal rules, in a way which interacts with the client. They answer questions and some form of advice is given to them. So here, for instance, we have the first a bit of the information collection process from the client's perspective. So you can literally log on. You can do this yourself. If you've got a parking ticket, you can go and see what it will tell you that you can and can't do. And it takes you through some of the possible defences, collects information, and at the end, it will provide sort of some very basic advice. Usually it's pretty general. You may have a defence in these terms. You probably need to seek legal advice, or if there's something very specific it will tell you that more specific thing. The interesting thing from the point of view of the business is what it does is it collects all that information and can produce instantaneously a brief to an advocate who can then, if the client wants to, can represent that client at court at the local mags on a fixed fee basis. And that's all automated from the client simply interacting with system. Here's another example at a different point in the market, if you like. Allen and Overy's over-the-counter derivatives initiative. Similar kind of idea, a bit more sophisticated in the way that it interacts with the client. It's called Margin Matrix, and it's targeted at the derivatives market. It helps with the negotiation of over-the-counter derivatives, drafts tailored documents, so the people working in the investment bank, wherever it is, fill out the information and the documents are produced. It delivers some automated legal analysis, so you need to be thinking about issue X or issue Y. And in efficiency terms, we're told, we don't have any external validation of this, that 3 lawyers' hours are reduced to 3 machine minutes. So you get a sense of how much the human labour from the law firm is reduced right down very quickly, and it also reduces the logistical challenges for clients. They don't have to think about the processes and so on. They can simply subscribe to this system and use its products straight away. Couldn't resist, though, having a little bit of a dig at one of the bigger law firms. Here's a quote in the story. In the first major collaboration between an international legal practice and one of the big 4 professional service firms, technology created by A&O is being supported by Deloitte, which brings a disciplined, process-driven approach to the product. Why can't law firms bring a disciplined, process-driven approach to the product? Perhaps the business school will be able to tell us on that. And whilst there's a sort of a little bit of a sneer there from me, there's also an important point, which is it probably hints at some of the difficulty, some of the complexity of managing an expert system which is heavily programmed, which is heavily rule-driven, where you have to write out the rules in a codable way and develop a system which interacts with users in a way which works, which is stable, because things change all the time. The way that users deal with the system changes all the time. If road traffic law changes, poor old Martin Langan, who designed the system, has to rewrite that bit of the program, and I think he told me there's something like 2 million pathways through simply a road traffic representation program. So they get very complicated very quickly, and there's a risk of instability if you don't keep on top of it. But there are people who can help with that. So Neotologic are an interesting company who provide a platform which enables lawyers, rather than having to learn to code or hire a computer science grad to build systems with them, you can use the Neotologic platform in a kind of drag and drop way to develop systems, expert systems which interact with your staff or your colleagues, or you can build one for your clients. And here are some of the areas in which they have worked: so data security, trade regulation, and so on. So they're kind of circumventing the programming part to enable lawyers to start to see in a relatively, and they've done this with my students, shown us how it works, a really rather painless way of building quite quickly expert systems which should work. So if you can build them quickly, then you can test them quickly and improve them quickly, and so on and so forth. They never tell me how much it costs, of course, so I can't tell you whether it's really worth the stick is worth the candle, as it were. And they have a more sophisticated suite of, if you like, question types that you can draw on. So it's not just a question of decision trees with yes/no answers which direct you in a particular way. They have ways of balancing lists of factors and employing some sort of gentle artificial intelligence to managing people's ways through the platforms. One of the interesting things that they told me also is that the way that when they sit down and plan with lawyers some of these programs, lawyers tend to think of all of the different permutations, however, if you like, unlikely they might be. And they told it was an HR program, so providing advice in relation to employment issues. And they found, and they started off with 20 questions initially that were always asked, and they found very quickly that actually you could provide pretty much all of the service by asking 5 questions first. And that, of course, increases efficiency and usability, because the user doesn't have to answer 15 questions which don't really seem relevant. So there's a sort of a process of evolution and development which can improve efficiency and so on, they say. Okay. So that's decision trees, expert systems, managed platforms, however we want to label them. And they've been around since, the 1980s. I remember the Listen Grove Welfare Benefits Programme, for example, any of you from the welfare benefits sector. There's tax ones, there's all sorts of different ones of these. There's sort of the new kid on the block are chatbots, which are a way essentially of disguising or making the managed pathway a bit more user-friendly. So here is Do Not Pay. You probably have heard of Do Not Pay. Josh Browder being the Stanford grad, I think, who came from he's English anyway, and he went over to the States, developed this chatbot, Do Not Pay, which he says has helped tens of thousands of people challenge their parking tickets. And in preparation for today, I thought, Richard, it's about time you went and had a look at one of these chatbots and see how they worked. So I created an imaginary situation where my wife was pregnant, please God no, and and we had to drop her off for an emergency at Heath down the road, and and the system coped with that in this way. So I typed in parking ticket, and I can't see where I am. I got offered these options. So there was the option that I was looking for. There's a medical emergency. And I filled in some of the details so you can just see what I was typing in. So I was trying not to defeat the system, but I was trying to just sort of how might I respond. So that's how I typed in the answers. And really, in a matter of milliseconds, when I clicked the next button, I got a letter to send to the whoever it would be on the parking ticket. They didn't tell you who to look for on the ticket. And I'll just give you a second to read it. Now, my grammar is quite bad. If you read the blog, you will know. I get told off for it all the time, but it's nowhere near as bad as this. And it's sort of slick and terrible at the same time, I think. But it does provide a starting point. I mean, I could go away and use that, and you can get it emailed to you. You can use it you can take the text and amend it. So I think probably actually it's quite useful for me. I could go away and just redraft it a bit, tidy it up, not maybe call Leanne wife, for instance, and it would probably be useful for me. It would be in the sort of design jargon, be a minimum viable product. It's something which is useful, which will encourage me to do something which I maybe wouldn't have done before, or to do something more simply, more cheaply than I would have used it before. It's good enough for me to use rather than being good for me to use. And in design terms, in legal terms, does probably something quite important, which generally we, if I can call the legal services community we, aren't terribly good at, which is getting people over the threshold from having a legal problem to dealing with a legal problem. It does it effortlessly, costlessly, cheaply, not very well, but well enough, just enough to get us started, if it doesn't expose me as the user to too much risk, or indeed the seller to too much risk. Yeah, so if I was going to do something which meant that I was going to get into a whole heap of trouble with the person I was taking on, so let's imagine the parking company could reclaim legal costs from me, well, that would be a whole different kind of worms opening up there. But because it's quite simple, and because there isn't really much risk to me or to Do Not Pay, it probably works. It also, I've blogged about this, but I haven't said it here, it also encouraged me to lie to the parking company, which is probably not such a good thing. So there are problems with these kinds of systems, but they are interesting, at least first starting points down the road of encouraging more access to justice. Or this is Levitz wrote a very famous piece on marketing myopia. His emphasis was on stopping thinking about what products you deliver and think about what the user really needs. If you've heard Richard Susskind talk, Richard always does a little riff about drills and holes. Don't think about the drill that you build, think about the hole that the consumer needs. And Do Not Pay is thought about the hole, and all I need is something that might get me out of my parking ticket. If it works, brilliant. If it doesn't work, well, we tried. It doesn't really matter too much. That, of course, is not such a good idea with more significant legal problems. And it's worth thinking a bit about design. They seem to be becoming increasingly important in thinking about legal services, partly because it places a greater emphasis on user needs. Here's a very nice, neat, low-tech example. Candy Chang is the woman who designs this. She's got a site. You can go and look at some of her examples. It was a leaflet for street vendors in New York to deal with what I put here is overzealous police officers, police harassment, if you like, and it provided them with some advice about how to position their stall, what to do if the police contacts them, and so on and so forth. And it does it in a range of languages with a range of visuals. So there's a certain basic set of information you can get visually, whether or not you understand the words as the street vendor, and then some more detailed information, but quite simple information provided in a suite of the main languages which street vendors might draw upon. It's not just, though, this kind of idea of design and visualization is not just for that kind of low-tech or if you like, a particular kind of client. It is used in the commercial sphere, so it's used to help visualize procurement processes or contracting processes. Berwin Leighton Paisner had a person who was recruited to deal with visualization in relation to their contracts. Interestingly, I think that's the first one I've heard of in that particular sphere. And here's another example of visualization being used in relation to trying to deal with varied levels of privacy requirement, consent to various levels of privacy requirements through symbols rather through, if you like, detailed contracts. Now, probably something detailed would lie behind it, but in terms of an interface with the users, that's a way of conveying information, getting people to use and understand legal problems in a variety of contexts. Second thing I wanted to say about information was the way that information is being used to better understand legal needs, particularly in the commercial sphere, or better to understand how to market legal services, or to better manage risk. So a different way of thinking about bear with me a second. Thinking about no, I'll carry on. Thinking about information, and this is where we start to get into some machine learning. I'm not going to try and explain the machine learning processes to you, because as I explained at the beginning, I sort of only half understand them. But the idea that you can extract from unstructured data from documents or semi-structured data, we might think of a contract as sort of semi-structured because it has a sort of a general format to it, and use that information in ways which help the clients or help the lawyers as businesses. So there are increasingly large numbers of providers using data analytics approaches, machine learning approaches, which learn to read and extract information from documents, especially contracts, as sort of semi-structured documents. And here you have sort of the highlights, some of the ideas that they might seek then to take away. Kira is a Canadian company that does quite a lot of this. They have a program which very quickly is able to learn from, identify contract clauses. So if you had a client who had, let's imagine a CEO, this is an example that was given to me by another provider recently. A CEO comes into an organization very quickly and wants to do some restructuring and wants to understand what the legal risks are around that restructuring. And he gets the GC and he says, well, what do our employment law contracts tell us? And the GC says, well, all of them? And he says, yeah, what do they all tell us? And the GC thinks, well, they're in the filing cabinet over there, or they're in a file on the hard drive. And we could go and look at them, but it's going to take us, a while to go through and extract the information that we need to be able to advise you on that. We've got a sort of general sense, but it's very general because, I only came here 2 years ago myself, right? The contract analytics system enables them to read in the contracts automatically, drag the PDFs in or the Word files or whatever they are, or scan them in and then drag them in if they're still in paper form, and then draw out the sort of key clauses, termination agreements, salary levels, whatever it might be, that the information that you need to extract in general terms from the contracts to provide some kind of profile of risk. These systems can do it pretty quickly because they've developed training sets, big banks of contracts which they've already learnt on, and they can use the same or similar models to help you learn on the contracts in your organisation or your clients' organisation. Second thing that's possible is data visualization. This is from a company called Brainspace, and I've left the link there so that you can go and look at the video. There's quite a long video explaining what they do, and this is just an interesting example of one of the companies working in this area, particularly around e-discovery kind of exercises, but also investigations, also due diligence exercises. So you have a whole bunch of documents electronically, say in a deal room or wherever it might be, and you want to try and understand what they tell you. Well, where do you start? Well, you could start looking for particular search terms straight away. Fraud, I'm interested in fraud. Well, let's type fraud and see where fraud pops up. Well, that's not going to be very useful, right? But what these systems do is they automatically categorize your documents. So they recognize different document types, the people involved, and so on and so forth, to try and provide you with a map of what information is there very quickly. You can get a little bit of a sense from here. So documents covering companies, albums, films, work, school, research, whatever. And so they sort of cycle out into smaller and smaller clusters of documents where you can start to pick out what you might want to look at. So you might want to talk about pricing and sales, and a certain change in the discussion around sales in the pricing in the sales team if you're worried about cartel for behavior, for instance. Yeah. One of the most famous examples of the use of this kind of technology, wasn't this system, it was a different one called Nuix, I think, is the Panama Papers, where this kind of visualization, this kind of clustering analysis was used to build up a picture of what had been leaked to them, and then to start to do things like build the links between the people involved. So it can identify people or organizations, proper nouns if you like, in the documents, and start to build the links between, map out who is talking to who, or who is talking to who when, or who stops talking to who when, which might be important. Suddenly the CFO and the sales team go offline on a topic 2 weeks before a particular deal is done. Is that suspicious? Does that require further investigation? And some of the systems, I understand, I haven't seen this directly, can deal with, for instance, textual data, but also sound, voice data in a similar kind of way. So in this way, they can start to build up quite interesting patterns, routes into further investigation. To give you another example which hit the papers recently, a senior employee in an organization was in the process of being fired, and they decided that what they would do is they would blow the whistle on financial irregularities in the company. It just so happened this was when the accountants were in doing the year-end accounts. They were in the process of certifying the accounts, and obviously if the whistleblowing allegation was unresolved, then they were going to have to qualify the accounts. So very damaging for the organization. Using techniques like the ones I've just outlined, they were able to speedily look at the documentation, isolate that documentation, and discover that the person, the whistleblower, had in fact created documentation alleging financial irregularities which were forgeries. Yeah? And therefore able to manage that person out quickly without any difficulty in relation to their accounts, speedily and relatively cheaply compared to what could have happened, for instance. Okay. So that's all I'm going to say for now about information triage. So this is the medical term, the process of deciding whether or not there is a case that is worth taking on, or how that case might be progressed. You might decide this is a case that's worth taking on, or this is a case that we're going to head down the settle at all costs route, or the litigate hard route, or however you might want to think about it. So how can technology assist with triage decisions? So here, perhaps slightly counterintuitively, I think we're talking about work that has been done around judicial prediction or legal prediction. And to link to the previous section, some organizations are using that kind of data extraction from documents like contracts to predict the outcomes of legal cases. They are extracting, if you like, variables from those documents and using that to try and support legal prediction. There are other ways of doing it. So here, this is the only academic bit of the piece, really. For years, academics have been trying to work out how judges decide cases or how lawyers decide cases, how outcomes can be predicted. And for years, we've had a sense that actually machines can do this better than human beings, at least in certain circumstances. And this is common across all disciplines. It isn't just true of law. So here's perhaps the most famous piece by Ted Ruger and others, where they used a database. So they had a database of variables. There were only 6 variables, and they weren't really legally sophisticated variables. So there were variables that almost anybody could code from legal information. Things like who was the judge, what circuit had the case been appealed from, this is US example, was it a civil rights case? Those kind of very basic variables. 6 variables, only 6, so no complexity really to it. And from those 6 variables, the algorithm, it's just a formula, was able to predict whether or not the Supreme Court would reverse or affirm the decision significantly more accurately. They got it right 75% of the time than the experts. So the experts were appeal attorneys, US academics, and people who had been clerks in the Supreme Court as well. So that was the expert group. The experts got it right 60% of the time from 6 variables. And what they did was they built a decision tree, so a bit like the expert system we talked about before, for each judge. Interestingly, the decision tree for each judge was different, so they weren't acting consistently. And it wasn't, as you can see here, it wasn't really, to get to accuracy of predicting the outcome, it wasn't really to do with, the legal arguments in the case or the facts in the case. It was really just very basic information about the case, which enabled them to get it right 3/4 of the time. Right, so interesting. A little bit unfair on the experts, because actually if you look at the very small number of appeal attorneys, actually they did really well. They got it right 90% of the time. So we need to take some of the kind of like machines do it better than experts with a little bit of a pinch of salt, but it gives you an idea of how you could take basic triage decisions. Should we run this case? From actually quite limited information on the case. You don't necessarily require very sophisticated legal analysis to decide whether or not a case is worth taking on. Maybe, I'll come back to that. Okay, here's a second study. This used over 100 variables, pre-collected again, so somebody's created a big database of Supreme Court decisions, Dan Katz and his colleagues. If you're really interested, if you want to have your head bended by random forests and this kind of thing, read that paper. It's kind of interesting, but it's quite hard going if like me, you haven't got a history of looking at this kind of information. And they built a model from the database which sought to test whether they could find a way of predicting Supreme Court cases across a whole 200-year period. And again, they did pretty well. The green is when they're getting the predictions better than what they called a rule of thumb decision. I won't bore you with that, but the green is when it's working well, and the pink is when it's working less well. So they started to build a quite complex algorithmic model which was starting to predict Supreme Court cases from the database really rather well for the vast majority of the 200 years. Now, from the point of view of a use case, the question that I would have is, well, yeah, but you've got loads of pink right here, right at the end. So it was working really nicely in 1995, but come 2015, ain't really working very well, so what good is it to me? Okay, so maybe it's a kind of theoretical case study at the minute. Here's a third one. This one made the press here, so you might have read a little bit about this, using natural language analysis, natural language programming, processing to analyze European human rights cases. I've written a little bit about this. I could talk about this in more detail, but in broad terms, what it does is it tried to predict the outcome of European human rights cases simply by analysing the first 2/3 of the judgment. And all it did was, in basic terms, was count the different kinds of words in the documents and see if there was a correlation between the words in the cases that won and the words in the cases that lost, and use that to predict. It's called bag of words technique, and use that approach to calculate whether the case was going to be lost or won without actually the computer reading the last bit where the result was given. Now, there's an obvious problem there, which is the judge might write about a case in a slightly different way if they're going to grant the appeal than if they're going to decline it. But that aside, and that is a substantial flaw in the research, I think, but that aside, it's an interesting example of the kinds of things that are being tested out as ways of analysing decision outcomes. A final example, before I show you one real-world example which is being used by solicitors, is the SRA have done some modelling of risk and enforcement using techniques a bit like, probably a combination of the Electros type approach and the Dan Katz type approach, and they've started to build a model which they think can reasonably accurately predict whether or not a firm that they've started to look at is a firm that will actually eventually get successfully enforced against. Yeah, so they're building up from their information on solicitors' firms a model of risk which may help them take decisions about who to enforce against, who not to, who they don't need to worry about so much. The room went very quiet. Oh God, you're thinking, oh blimey. Right, so a couple more examples. Case Cruncher, again, this got a lot of attention. Some Cambridge grads built a machine learning system, looked at PPI complaints. They got loads of FCA decisions, reports on cases, and built an algorithm which correctly predicted the outcome of those cases in 87% of cases. They were able to look at just over 20,000 cases, so very high levels of accuracy there. Might have the same problem as Electros, we don't really know because they haven't published any details of their study. They had a sort of a face-off between the machine and lawyers, which were lawyers from city firms, GCs and some barristers. Commercial lawyers, but not particularly FCA PPI lawyers, in fact not generally FCA PPI lawyers. And the lawyers got it right 62% of the time. And were only able to look at 483 cases. So you have a sense there both of the difference in accuracy and the difference in volume of work that can be done using a system which probably not that complicated. Again, like I say, we don't know very much about it. One final real use, Hodge Jones and Allen, legal aid firm, personal injury firm in North London. Building up a model with a colleague of mine, he's actually an economist, to assess risk on their personal injury cases. And they've been treading very cautiously, very carefully, building up understanding of the model for 2 or 3 years now, and not yet, at least not saying publicly that they're using it to actually take decisions, but getting ready for the point at which they are willing to use it to help decide which cases to take out on, or perhaps what their margins might be on CFAs, whatever it might be. Okay, triage done. Negotiation and, oh gosh, right, time. Negotiation, litigation. Well, read this book. It's a brilliant book about checklists. What I wanted to say about this is the systemization of negotiation seems to be about making processes simple rather than really trying to capture the legal complexity, trying to nudge people towards solutions rather than fight about what's gone on in the past. I'm going to have to skip through amicable. Here's another example of design meeting technology. Amicable built an app to which they hoped to build the world's best app for divorce, and you would tap in your details and it would sort of kind of sort out all the documentation for you. So you'd sit down with your ex-husband or wife at the kitchen table. I'm relating to this a little bit, and just sort of, oh yeah, we'll do this, darling, and we'll do that, and we'll do that, and everything will be fine. Time, all the paperwork comes out, and they discovered that actually people weren't interested in the app. They liked it as a gateway into getting service, but they still wanted to talk to real people. So they built a service around the app to try and deliver amicable divorce solutions to their clients. That's their sort of commercial offering, if you like. Litigation negotiation can be supported by analytics. So Lex Machina in the States, intellectual property cases, have a whole database of cases which enable lawyers to look at how different judges behave, different courts behave, so they can decide where to issue, what kinds of motions to take before particular judges, or even they're starting to say what kinds of arguments to run before particular judges. Judge X likes these kinds of arguments, Judge Y likes these kinds of arguments. There are interesting outfits like Picture It Settled who try and advise you using data analytics on how high or low to pitch your offer. Okay, so if you ask for 2 million, negotiations are going to break down. If you ask for 500,000, you're going to settle tomorrow, but you might have undersettled. You know, that kind of idea. Various other ways of automating negotiations, preparation. have I got 2 minutes to say something about this? Sorry, I'm overrunning a bit. So the kind of the critical thing, it's true about litigation negotiation, is a lot of what lawyers do, you simply cannot automate at the minute. You cannot automate the strategy, the delivery of the strategy, the application of a strategy to a particular set of facts, the nitty-gritty of managing the case to settlement, persuading the other side to settle, or persuading the judge that you're right, or getting the deal to completion. But people are starting to talk about deep learning, neural nets as a way of starting to understand law and legal reasoning in ways which might start to replace lawyers, basing their argument largely on the fact, well, we've done it for images, why can't we do it for ideas, legal concepts? And one reason might be this rather lovely quote from Wendell Holmes in the United States, is that law is very contextual, meaning is very contextual. The meaning of words shifts around all the time depending on how that word is placed, what the broader context of that word is, what the broader context of that sentence is, etc., etc. Very, very hard for computers to do that kind of analysis. They're not really anywhere near being able to do that yet. They started to build up some simple models, but not some complicated ones. But there are, if you're interested in thinking about where things might be developing, go away and look at Cara and Eva, run by Casetext and Ross. There are systems in the States now, they aren't over here, where lawyers can drop their brief or their opponent's brief, their opponent's arguments, their own arguments, into the system, a skeleton argument if you like, into the system, and the system will tell them whether the cases that they use are up to date, whether they are perhaps using the best cases, whether they might want to think about a slightly different point. So they're starting to advise the lawyers on how to improve their own arguments or how to attack the arguments of their opponents. It's a kind of a supercharged Google. So it's finding, you're talking about restrictive covenants in this context, and there are these cases about restricted covenants in this context which you might want to go away and think about. And Eva can provide some very brief legal summaries, kind of meta-analysis of the legal points in those cases as well, as I understand it. So they are starting to actually assist the lawyers in preparing the cases. Eva is interesting because they've started to provide this service for free to lawyers in the US. Cara you have to pay for. And one of the reasons they're doing that is because every time the lawyer interacts with the system is learning a bit more about how lawyers think. So they're starting to try and build up models of how lawyers think that way. If you're interested in that sort of stuff, read this book. It's kind of, read the first chapter and the last chapter. It's really interesting. Adjudication, well, I maybe shouldn't say too much about adjudication other than we're nowhere near computers being able to decide cases, but there are ways of getting crowds or juries or remote juries to decide cases, some of them quite worrying. And we are already using risk algorithms. In fact, we have been for a long time. Scotland had a sentencing support system back in the 1990s, which was designed by academics up at Strathclyde, which, amazingly enough, the Scottish judges were using for a while. So we've had artificially intelligent assistance systems for quite some period. I'll end here. I was going to say, but there are a whole bunch of problems, both from a kind of a public policy perspective and from a practical perspective. What I hope you can see is that at each stage of the legal process there are things that can be done which are being used now which can improve service or make your business more effective, or that can deliver different kinds of services to your clients if you are willing and want to invest the time and the money to work up something that actually will work for you and work for your clients. Leave it there. Sorry about overrunning.
Thank you.
I'm not doing anything.
Any questions for Richard?
Don't think so.
One's an observation, sorry, Robert. One's an observation, and the other is a question. So, someone actually, just for information, was another advocate. Someone introduced me to something called Seed Legals, which you're probably familiar with. you're not, it's basically UK funding rounds made simple, easily create a negotiated sign all the legals you need to do a funding round online. And that's just part of the narrative that you've been outlining this morning, I guess. But here's the question, where are we going? Where are we headed with this?
I only know a little bit about Seeds Legal. As my understanding, but this might be wrong, is it's a venture capital backed outfit which is looking for opportunities to invest in good ideas, and what venture capital outfits generally want is ideas which will quickly scale up and make lots of money, and then they can exit out.
It's a combination of entrepreneur and someone with a legal background investing in your own benefit claims, legal fees, and deciding to put this online vehicle,
Mm.
etc., to deal with the legal documents around raising money, etc.
Mm.
Let's just by the by.
So where are we going? I don't really know where we're going. I don't think people generally know where we're going. We've got the sort of the basic stuff around analytics and process. I think we will see that increasingly being adopted by legal service providers, either in-house or in firms. There's quite clearly an appetite for legal service providers to go down that route, both the big commercial firms like the Allen & Overys and Berwin Leighton Paisners of this world, and the smaller firms, still quite a big firm, like Hodge Jones and Allen. So I think we'll see more of that kind of work because it will sort of become natural. There'll be products which will plug in and play that people can use if they don't want to try and work with people to build up their own. So those things that can be automated and improved will be adopted on the whole. The bigger question is the question of, if you like, around the last bit of the picture, which is the automation of the really complex, difficult bits. And as I understand it, and this is really beyond the limits of my knowledge and understanding, but if you read the Ashley book, for instance, there is a very clear sense from that we are quite some way from really being able to model legal arguments, legal complexity in a way that the computer will be able to reason in a way that approximates to lawyers. So I think that's one of the key sort of blocking points which we will hit, or which will inhibit, if you like, radical reorganisation for the next sort of 10 years or so. So adoption where it's currently working, I think that will grow apace, but the bigger picture, the kind of robots taking over lawyers' jobs bit of the picture, I think, for now at least, I think that's rather exaggerated.
Could we see it becoming sort of a gateway to actually go to court, particularly on the court of view where the judges already have a gateway to the judicial system in most places around the world? Something that can do that in the judgment.
You could talk. I mean, so you could imagine a triage system which read the appeal papers and took a view on whether it was likely to succeed or not. The interesting thing would be how would that work at the minute? So what it would do, these machine learning algorithms, when they're analysing text in this way, they pick up on the simplest way of modelling that decision, reject or accept for appeal. And so the machine learning model would probably pick up on something like, are they represented or are they not represented? So you'd have a model which immediately just excluded the people who weren't represented, which in some ways would make the Court of Appeal quite happy, but would obviously exclude a bunch of cases which should be accepted. So for now, I think probably those systems aren't sophisticated enough to manage those kinds of decisions. It's why, one of the reasons why I hope the SRA aren't really using their system for and I suspect they're not, they're just learning at the minute. So something like the Court of Appeal, I think they'd be very wary because there's a very strong public interest in taking that decision properly. But a commercial outfit that has to decide which cases to take on isn't subject to the same level of scrutiny, actually rather likely to use the crude rule of thumb to decide which cases to take on. And if the computer can help them with that, then they will adopt that system. And from a public policy perspective, that will mean certain people get excluded who wouldn't otherwise benefit from an automated approach. That's got to be a risk.
Yeah, so talking very much about the tech today,
Yeah.
I just wonder to what extent you feel that the challenges and opportunities are just as much cultural as they are tech related. So, us lawyers, we're trained to identify risks and manage risk averse, really. So,
Yeah.
you know, does that mean that it is just as much a cultural challenge in terms of, you know, exploiting
Ye-
the tech that's out there?
Yeah, I do think that's a large part of the picture. I think a lot of the work that needs to go into making these systems, it's back to the amicable example in a way, a lot of the work that needs to go into these systems is not about the tech, it's about what works around the tech, what the users need, how the lawyers will interact with the system or the advisors or whoever they might be, and the understanding that sort of those human needs and those human behaviours and the processes and systems that will enable the systems to work themselves. It's understanding those things, which is as or more important than actually, well, what can the program do? Because you can probably bend the program to your needs much more than you can bend the human behaviour to what the tech can deliver.
I know you were just poking fun at Alan Overy, but I think, you know, us lawyers are really good at the process
Yeah.
and the procedure. I think we can nail that, really. I just wonder whether any notes teamed up with Deloitte more, you know, to tap into Deloitte's innovation expertise, you know, maybe for other reasons. You know, I'm not sure, obviously, but you know, I think we can be good at the process side of it.
Well, a certain kind of process, maybe. I don't know about whether lawyers are good at process or bad at process. There's a lot of sneering at how lawyers deal with that, and again, I don't accept that that's true or not true. It does seem to be the case that getting people from different disciplines to work together on a problem leads to more interesting ideas about how to solve that problem, and then you've got to work out which ones to actually run with. So I think that would help break things down a bit.
Some of the things that we've been providing as a business school is around customer experience, analysing service experience, looking at some of the leadership and cultural elements that are required in order to create the right environment to make this stuff work. So I think it's definitely a marriage of the business approach, service experience approach, and the technology, and of course the legal expertise.
And I do a lot of work with in-house lawyers, and they tell quite interesting tales about how private practitioners relate to a legal problem compared to how an in-house lawyer relates to a problem. So a private practitioner thinks, right, you need a contract, you need this contract, we've had that contract, here it is, we draft it. Whereas the in-house lawyer would think about it, do you need a contract, can we just adopt this contract, how, you know, are there other ways of dealing with the problem? So it is about experiences as well as... Yeah. Yeah, so on the whole, I don't think I haven't made my mind up about this. I think it's I certainly don't think all lawyers need to learn coding or all new lawyers need to learn coding. I think there might be some benefits from law students or lawyers at any stage learning coding in the sense that it will help them to think about a different way of thinking about law. So thinking about how you can automate certain bits of law and how you might not be able to automate other bits. The technical aspect of being able to deliver systems that can employ those kinds of logics, it seems relatively clear that there are or will be drag and drop systems where you don't need, so Neota is an example of, you don't need to learn how to build the system, you can use their platform to build a system from a sort of drag and drop kind of approach without learning coding. So I'm sort of inclining to the view that it might be better to get lawyers thinking about bigger issues than how to write that line of code, but to get them thinking about the logic of how do you design a process that actually will work with in an artificially intelligent way.
I'm just intrigued whether you think that ultimately this is a threat to innovation. I'm just picking up on the point that the gentleman in the front was making.
Yeah.
I wonder whether this is as dramatic as you think it is, because if I go back, being in the law for quite a while, when I started my career, you were looking at case reports in printed volumes and having to know the reference and the page number and look it out, and so the company for getting to LexisNexis where I can download any case, I
jurisdictions I can search by, sending search terms. That's a bit of a revolution, and this to me seems in that line and not really that really different. And the difficult bit of being a lawyer, I think, is having those conversations with the client to say, well, we can win the case, but actually that's going to mean this. It's not actually going to give you the life results that you might want, or it's being involved and having to change directions. You can see that the judge is not with you, and a really good barrister is going to be able to just go swiftly change direction and hit the case in a different way. So I sort of maybe I'm a bit more optimistic that actually this is the fantastic
Yeah.
take what we're doing to another level, but maybe
Yeah, I absolutely agree. I was actually trying to be optimistic. Maybe it just doesn't suit my personality to try that. But it is about learning the tools and adapting the tools. I think, and if the profession's only got something to fear from this if they don't do that. If they don't do that, then other people will do it, like the accountants. But in broad terms, the profession can learn and adapt and use these tools. I think it will change the way that lawyers think about how they deliver law. So they will think in more managerial terms about process, and they will think about in somewhat more scientific terms about things like settlement and negotiation and advocacy and triage. So they will need to learn a more scientifically broad mindset, if you like. But if they can do that, but also they will have to do some of the less tedious jobs. I mean, I remember as a trainee having to go to a warehouse in Bradford in the daylight today and start to look through thousands and thousands and thousands of documents, not really knowing what we were looking for, just some sense that we might find a smoking gun somewhere, right? We won't have to do that. We'll be able to do more of the brain space. Let's look at what we've got. Let's really think about what we can find out, what it tells us that we hadn't thought about. So it's actually a much more exciting, interesting job on offer than it certainly was back in the day, and probably is now. It might mean might mean a slightly smaller legal profession, but we shouldn't really actually. I know we do. We can't help it, but we shouldn't really care about the size of the legal profession. We should care about what really works. Yeah. Yeah. I don't think we're technically near that, and I don't think politically, if you like, we're near that. I don't think as ordinary, if we can put our lawyers' hats to one side, as ordinary citizens, we'd be quite uncomfortable with a very automated approach to those kinds of decisions. I think there is a risk, though, early on in the stages, that there are certain decisions, sort of filtering decisions, if you like, that will occur, which we don't see. In the same way that people complain about legal aid decisions being taken by a bureaucrat in the legal aid agency, computers will be taking those kinds of decisions without us knowing, without much accountability, if we don't keep a careful eye on it. But in terms of running cases, fighting cases, negotiating complex cases, we're quite a long way from significant automation of the processes there. Yeah, it's a slightly strange idea, and they recognise the limitation. It's sort of an experiment. It's a flawed study, but it's an interesting example of what you might be able to do just by reading text automatically and forming a judgment from the text, rather than having somebody code 6 variables on all the cases.
Last question? Okay, well, thank you so much,
My pleasure.
Richard. We're really lucky to have you this morning. Thank you so much. And it's so fascinating for me. Obviously, my background's continuous improvement and lean, originated largely in manufacturing, and hand in hand with the advances in process re-engineering is the automation piece, is building and working with robots, with machines to advance manufacturing. And what we've seen, of course, is it's swept through financial services and now potentially legal sector. And what's been really interesting about your talk today is we need to work with machines to protect the creative intelligence that human beings provide within our service organisations. So as long as they're doing the mundane tasks that are a waste of our time, we can really work perfectly together to deliver fantastic services. So thanks ever so much, Richard. Still some coffee, I think, lying around if you want to grab a quick cup of coffee. Hope to see you at future events. If you've got any questions about any of the executive programmes that we deliver, please do get in touch. Okay, thanks ever so much. Thank you.
All right.
Yeah, it was great. I was like, oh my god, there's so much stuff. Can we send people the slides or not?
Let me have a double check. It's probably all right, but let me check.
Well, they can have the Panopto link and the slides with the Panopto link. Is that okay?
Oh, the visual?
Yeah.
Yeah.